Let's get to our interview with the guest of the day. I'm joined by a senior advocate of Nigeria, S.A.N.I. Akintola, to discuss the sack of Kano State Governor Abba Yusuf by the state's governorship election petitions tribunal. Senior advocate, thank you so much for joining us this evening for some legal perspectives to that judgment. Thank you so much, sir. It is a pleasure.
Thank you for having me.
Right. So the Kano State Election Petitions Tribunal invalidated the victory of NNPP in that state. What will you consider as instructive in the judgment?
Well, in the first place, what happened in Kano yesterday is not novel, was never novel, it's not strange. It has happened before in this country. And if you look at if you listen to the judgments, and look at the reasons behind the judgment, the reasons advanced by the tribunal, you discover that they anchored same on two major planks. One was electoral malpractices in the area of ballot papers that were said to have been manipulated, as many as 160,000, 165,000 or so, that we are said to have been manipulated and that we are neither stamped nor signed, nor bear the stamp of INEC. And that's a very serious offense under the Electoral Act, Section 63 to be precise. And I listened to some commentators stating that, well, in spite of that, the electoral officer still has the right to make such valid. They've forgotten that the following section of the Electoral Act, they limited themselves to Section 63. If they go further, the holistic reading of the Electoral Act, because don't just read a section in isolation of others. The holistic reading of the entire gamut of that chapter of the Electoral Act shows that the tribunal has the overriding supervisory role to play on. So even where the electoral officer confirmed that, well, in spite of the no stamping, no signing of the ballot papers, you want to render same valid, it is the tribunal that has the final say. That is if the tribunal agrees with the electoral officer of INEC in that direction. And in any case, if you look at if you follow the judgment, there was no area where the respondent called any INEC presiding officer to justify the using of such invalid ballot papers as valid. In other words, if it's not valid, it's not valid. For you to rebut that, you need to call the umpire, those who conducted the election, if you are the electoral officer, and there was nothing before the tribunal that shows that the respondent here, that is the respondent in the election petition in Kano State, call any INEC officer to rebut the allegation made by the petitioner. So the election tribunal has the final say over it. And it is not new. I was privileged to lead a team that did the first of its kind in this country. That's Noshi Omole against Osumbo. That was exactly what we did. Ballot papers that were neither stamped nor signed, or those that were stamped but not signed, they were separated. And of course, I listened to the official of Kano State government in the morning saying, well, if that was done, why was it that it's tenured to the benefit of the petitioners? No. When votes are said to be invalid and they are deducted from the main figure, it tenures only to the advantage of the petitioner. The respondent in this case will be at a disadvantage. In other words, if it was decided that 10,000 votes be deducted from your votes, everybody loses. in that direction because it was something that is not peculiar to a particular kind. All the candidates involved in the election becomes victim of such manipulation and electoral malpractices. So there is nothing special or novel about it that has not been done before. It has been done before in this country, and of course, many other petitions have followed suit. So it's not strange.
All right. I mean, so since this judgment was delivered, there have been several arguments, and one of them is that it's strange for a popular candidate to win the election and lose at the tribunal. How will you react to that?
Well, my first reaction to that is that the media and those in the social media, the main media and those in the social media, should please allow the judiciary to do their job. Judges should not be intimidated. They should not be commanded. They should, if you know better than they, go to the law school and be qualified and be appointed a judge. You can't just sit out there because may that day never come. When judgments will be based on public sentiment, emotion, feelings, or what have you. Our judicial system is equitarian. It is justice according to the law of the land, not justice according to how you feel, or your emotion, or public morality. In any case, morality is an unruly horse. It takes you to where you don't expect. It's an unruly horse. What is morally reprehensible in one part of the country is accepted in another part of the country. So it's not something that you can put in the straitjacket and say, no, because people are saying it. In any case, who are those people who are saying it? When was the census conducted? Because I'm not always I see by people making generalized statements, people are thinking, who are those people? You see, our judiciary is becoming too media-driven in this country. And it's not done anywhere in the world. I mean, we have the opportunity of traversing the length and breadth of all the continents of the world, and we've interacted about people who practice in some other jurisdictions, and we've seen that nowhere is what's happening in Nigeria is happening. We are driving the judges. Can you imagine people threatening judges, showing the picture of their children? Even a commissioner in Kano State granted an interview, threatening the judges, even before the judgment was given. So I'm not at home with people who are insulating what we have just said. To me, judges should be allowed to do their jobs, and they should not be intimidated.
Right. So there was this part of the judgment where the tribunal said INEC shouldn't have declared Governor Yusuf winner of the election. What does this say about the election?
You get that question?
Right. There was this part of the judgment where the tribunal said INEC shouldn't have declared Governor Yusuf winner of the election. So I'm asking, what does this say about the entire process?
Well, the judges of the tribunal had the facts before them. They were there. You and I were not there. And again, when people make comments, generalized statement on a particular judgment, without reading the pleadings of the parties, cases are won and lost on the basis of the pleadings. And it is the foundation of the case. As a matter of fact, the judiciary has been so, lenient with litigants in election petition in this country. Because stricto sensu, if the law is to be applied strictly on the basis of pleadings, many petitions will not go beyond the day of mentioning, because many of them don't even stand the chances of any success in the first place. But because our people assume the role, the public, the so-called public, assume the role of know it all, quote and unquote, you and I have no power to decide for the judges. They have the facts. They know the circumstances. They listen to the witnesses. They look at their manuals. And all these other things that are associated with litigation are before the judges. So it is not open to an outsider who knows little or nothing. Because you see people coming over to comment on what they know little or nothing about. It should not be. The judges are the one trained in the area of laws. They understand the Electoral Act. They know what the conscience is. It's not about emotion. It's not about your feelings. And like I did say, may that day never come when judgment of our cause will be based on sentiment, morality, feelings, or what have you.
So again, senior advocates, looking at the numbers, 165,663 votes were deducted from the NNPP. What's your opinion about this? Some people feel deduction shouldn't be the case here.
Well, like I did say, what happened in Kano was not novel. It was not strange. It was not new. It happened in Oshiomhale's case against Osumbo. And as a matter of fact, that was the first time a sitting governor was removed through the judicial system in this country. And I was privileged to be the lead counsel there that led the team. So it was something that was novel then that was done. And in any case, people are getting wiser every day. Many petitioners, lawyers go the whole hog to do their own work, to look at the pleadings of their opponents and make the same. But if you sleep on your bed the way you prepare it, and people have to appreciate that cases are won and lost in chambers. Not in the court. You have lost the case before you leave your chambers through your pleadings. As a matter of fact, like I did say, the judiciary has been so lenient these days in the case of election petition. They've been so liberal because in ordinary cases, you are even on the first day, you'll be asked to address, look, counsel, can you address, look at paragraph 25 of your pleadings. Can you address us on that, vis-a-vis your claim, your release? If you are saying, for instance, like I had in one of the cases, I don't want to mention that where somebody was claiming that he won the election in the entire country. And he said he had 40,000, in his own plea, he said he had 40,000 polling agents, which is submitted to INEC, because you will have submitted that ahead before the election. But when you look at the demography of election in Nigeria, we are having 176,602 thereabouts polling units in this country. Now you look at 40,000 polling units of the petitioner. What is the percentage? Vis-a-vis 176,000. In other words, a petition ought to have been dismissed on the first day of mentioning the case. Doesn't stand the chance of any success. But because of sentiment, because of social media and all the noise, you see, Tribunal still bent backward to hear everything out, to hear him out. You see, what me met when I joined the profession, close to 4 decades now, it was, if you are on the basis of your pleading, sometimes you are sent out of the court. Your cases are thrown out.
But senior advocate, how worrisome is it that the deducted votes were neither stamped nor signed, and the election was considered conclusive?
Probably a mistake on the side of INEC, and unfortunately, the petitioner will not suffer them gladly. Because INEC itself was a respondent in the petition. The question is, what was their response to the petition? Were they able to defend that? What was the response of the respondent vis-a-vis defending the petition? Because INEC conducted the petition. And if you are saying, look, what you conducted, what you declared, 165,000 of the votes were invalid. And if it's invalid, it's invalid. You cannot even agree to do illegality, even if there is any agreement, because somebody was saying today that after all, the man who contested as the governor was not complaining and even congratulated the winner. They've forgotten that no one is allowed under our law to make agreement or to agree on illegality. The mere fact that your daughter, who's a minor, is not complaining that you have carnal knowledge of her doesn't absolve you of the criminal charge of rape. So in other words, whether you agree to the commitment of the crime or not, the law will still take its course. And we must appreciate the fact that it's not just the candidate that's contesting the election, even the party too is contesting the election. So if the party is a petitioner, can you deprive the party who sponsored that candidate its right to contest the election that was said to be invalid? No. Both the candidate and the party have the right to challenge any election said to have been conducted outside the purview of the Electoral Act and the Constitution of the Federal Republic of Nigeria. So, to that extent, that votes were deducted like this, it was not new. If the votes are invalid, they are invalid. No one can make such votes valid by mere wishful thinking or feeling, no.
Right. So, senior advocates, we'll definitely come back to this issue of APC governorship candidate conceding defeat. But then, in all of this situation, what's the place of the Beavers and IREF?
I beg your pardon?
What's the place of Beavers and IREF in this?
Oh, Beavers. You see, people
right.
have been
and
making
IREF.
mistakes. Beavers and IREF.
Absolutely.
And this Apex Court of the Land had made pronouncement on that in the case of Adeleke against Akintola. And that is it. When the Supreme Court made pronouncement on an issue, that is final. It is the Apex Court of this land. It's only the same Supreme Court that can change its position. Not by wishful thinking, not by anybody's whims and caprices. No. The Supreme Court has said, and rightly so too, that the Electoral Act never made Beavers and IREF sine qua non. People have been reading section 64, 65, upside down. You have to read the entire, the canon of interpretation, especially of the Constitution, of such crucial, of such importance, demands that you read the entire sections of the Electoral Act. You see, but people just key only to what they want to hear. They speak what they want to hear. Like the disco critics, they only listen to themselves. They only listen to others. You see, a careful look at other sections of the same Electoral Act shows clearly that Beavers was never meant to be sine qua non. In fact, INEC has discretion throughout. And again, people made recourse to INEC guidelines and what have you. My simple answer to that is that there's no time a rule of court to override the statute. It has never happened before. And because most of these people don't read, if they don't read, they will have known that the issue of discretion was long settled as far back as 1947. But that was the first case handled by our referred father, Baba Olowo. So the case of Laguju against Olubadan Council, if it appears to Olubadan Council that Laguju was not fit and proper to become Timofede again, at that time, the entire areas of Ede, Oshogbo, Ojigbo, Ikirun were under Ibadan control. And it was the practice then for the baalies in those cities to aspire to become Magaji in Ibadan. So, Laoye made attempt to become Magaji. He contested against Agbaje, Salami Agbaje. He lost. And he wanted to go back to reclaim his throne in Nede. But in the process of doing that, he was very rude to the Olubadan Council. He could not go back there. And the Chieftaincy Ordinance was very clear that if it appears to Olubadan Council, and it was so interpreted by West African Court of Appeal in Accra, that was when that principle was formulated. If you have a discretion, to give you my wristwatch, without any consideration. If I refuse to give it to you, what can you do? There's no consideration, no contract whatsoever. So in this case, the principle of discretion operates in several cases across this country. And as late as 2011 here, AIC case, the Supreme Court set aside its own rules to follow the law, the statutes. Its own rule, that was the Supreme Court. So people should appreciate, but because most of these people don't read, and they assume that they know more than every other person. And that's where the problem is. And again, like this, the media, the judiciary is becoming too media-driven. And the judges too are not doing anything about it, because most of the commentators who comment on matters that are still pending before the courts have been sent to jail for contempt. A lawyer and his journalist friend were sent to jail by Chief Justice Oyemade, the whole Chief Justice of Nigeria, the Chief Justice of Western State. It's there in our laws. But they close their eyes to it, and they just... So many of the judges are becoming timorous souls, where they should act when the laws of the land or the rules of court are being flouted. They do nothing about it. Even senior lawyers come before television station and radio, and they be commenting on matters that are pending in court. It's not done. It's even unethical. But that's what we're having now. You can comment and scrutinize judgment after it has been given, like we are doing now. But why the matter is still pending? For instance, if this matter is appealed tomorrow, I will not come back here tomorrow to discuss this. The moment the matter still sub judice or still pending in court, I won't come before any television or radio station to comment on it. It's unethical.
All right, student advocates, let's take a break. I've been speaking with Akintola, SAN, and tonight we're discussing the sack of Kano State Governor Abba Yusuf. This conversation will return when I come back. Please stay with us.